Hello and welcome to our show, 60 Seconds with Sergio. I am your host, Sergio Cabanas, attorney at law here in Florida. Thank you for joining me today. Today's question is, Sergio, I need to obtain a restraining order against my spouse to protect me or my children from physical abuse. How can I obtain this protection under Florida law? Well, first of all, if you believe that some type of domestic violence took place or is about to take place, please seek help as soon as you can. Call the police immediately and seek medical attention if you need it. There are also many public services and agencies that are available to help families through such a crisis. Please consider reaching out for their help. If you contact them right away, the police may take steps with assisting you by arresting the person who committed the domestic violence and otherwise pursue criminal charges against that person, including obtaining a no-contact order that prohibits that person from contacting you. But today's question deals with those cases where the domestic violence occurred or there is a reasonable threat of domestic violence, but the police are not assisting you for whatever reason. You can take steps to obtain a restraining order on your own without the need for police intervention. First, let's see if your case qualifies for a domestic violence case, or what we call DV case. Domestic violence is basically any type of unwanted physical attack or stalking. This includes sexual assault, stalking, kidnapping, false imprisonment, or any other type of criminal act that results in physical injury. The definition has been expanded to include any reasonable threat of domestic violence. The domestic violence has to have been committed by one family member or household member against another family or household member. This includes spouses, former spouses, or persons related by blood or marriage. This also includes persons who are currently living together or lived together in the past as family members, or if they have a child in common, regardless of whether they were ever married. The courts primarily look at three main factors to determine if a domestic violence or DV case justifies a restraining order. Number one, the severity of the actual domestic violence act. Of course, the more severe the act, the more likely the court will impose a restraining order. It's important to have evidence, such as photos of injuries, if any, medical records, police reports, and witnesses whenever it's possible, although it may not be necessary. Number two, the timing of the domestic violence. The more recent the incident, the more likely the court will seek to protect you. If you wait too long without a good reason, the court may consider the possibility that you don't really believe that the restraining order is necessary to protect you from future domestic violence. So, the sooner you seek the restraining order, the greater your chances of success. Factor number three, the frequency of the domestic violence. One particular act may seem minor, which in of itself may not justify a restraining order. However, the more often that act occurs, the more likely you are to obtain a restraining order. Try to get as much evidence or witnesses as applicable to help your case. So what should you do if you're actually only dealing with a threat of domestic violence? That is, the domestic violence had not yet occurred. So you don't have any of these factors, such as the severity, timing, or frequency of any domestic violence that the courts will normally consider when awarding a restraining order. The courts will simply impose a reasonable person standard to see if the threat really exists, as opposed to a threat that you might believe exists only in your mind. For example, your spouse may be angry about the fact that you started dating another person. Your spouse may say, if you continue dating that person, I'm gonna do something you're not gonna like. Well, in your mind, you're thinking your spouse is threatening physical violence, and you could be right. However, the court may find that such a statement in of itself does not constitute a threat of domestic violence, as it could refer to anything else. However, let's take that same example, except that your spouse is pointing a knife at you as he or she is making the statement. It's likely that a reasonable person would agree that this act now constitutes a threat that would justify a restraining order. I hope this short video provided you with some guidance about obtaining a restraining order in domestic violence cases. Remember, this is not a substitute for an actual consultation with an attorney who could review the specific facts of your case. Thank you again for joining me today, and as always, stay informed so you could stay strong.